get it as you walk out.
Can we send a letter of thanks to them?
Absolutely.
Thanks. Yeah, that looks great. Any other public announcements? Okay, if not, 5:30 p.m. we have an appointment with Attorney Lauren Goldberg from Copeland and Page to review special municipal employee status and its purpose. Hey, Lauren?
Members of the board. So you'd asked me to essentially give you information about special municipal employees and why special municipal employee status is important. So I will, essentially a special municipal employee is only designated as such if they qualify. So if a position qualifies, and in order to qualify, it either has to be an unpaid position. It could be a part-time position, which allows other work during normal working hours, so like a part-time or half-time position, or a position for which you're not paid more than 800 working hours in the previous 365 days, which comes out to about 20 weeks of full-time work. Now, the way in which a position is designated as a special municipal employee position is by a vote of the Board of Selectmen. And once a position is designated as a special position, it remains as a special municipal employee position until the board votes otherwise. Okay? Now, the Board of Selectmen in towns less than 10,000 are specials. Otherwise, the Board of Selectmen are not specials, and it's only other positions that can be designated as specials. The board should be voting separately on each position. So that's going to be designated as a special, although if you had a list, you could take the list and vote on the entire list and say with each vote to be considered a separate vote. It is the position that's designated as special and not the person. So let's just say hypothetically that a member of the bylaw review committee came and said, oh, I'd like to be designated as a special. If you guys voted to designate an individual as a special, let's say Kathy, because she's not here and we can take advantage of her, that isn't the way it would work. It would be to vote to make all the members of the bylaw review committee special municipal employees. Okay, so it may be that there's one or two people that this would be beneficial for or important for, but it's the entire board that's designated in that. Now, conversely, if it's a particular position, if there's just one, let's say there's a part-time inspector, and you vote to make the part-time inspector position a special municipal employee position, then that position, just that position would be. But if there's more than one of the same, all the people in the same class are designated, or all the positions are designated. There's been a question about filing. Several years ago, when the new state ethics law amendments came into effect, the State Ethics Commission sent around a request that there be notification to the Ethics Commission of which positions were designated as special municipal employee positions. Typically, the town clerk is the one that keeps that list. Okay? So the Board of Selectmen would notify the town clerk, and the town clerk would add it to the list of special municipal employees, so that if anybody wanted to know who's a special municipal employee, they could simply go in and ask for the list. And as I said, once that designation's been made, it stays there in place until it's rescinded. So a brand new board comes in, that brand new board, if the board has been designated, let's just take the bylaw review committee. The bylaw review committee finishes its job right now, and they say, thank you very much, we're done. And the Board of Selectmen appoints 3 new people to start looking at bylaws a year from now. That bylaw review committee position is a special municipal employee position, and it would remain so. The new people appointed would also be special municipal employees. Now, why do we care? And that's probably the more important part. And the reason that we care is that the conflict of interest law applies less restrictively to special municipal employees in 2 particular ways, or under 2 different statutes. First, let me be clear that under Section 19 and Section 19, Chapter 268A, Section 19, that section prohibits a municipal employee from participating in a matter in which they have a financial interest, unless, if they're appointed, they receive an exemption from their appointing authority. If you're elected, there is no exemption. And whether you're a special municipal employee or not, it doesn't matter for Section 19. It's saying you can't participate in a matter in which you have a financial interest, if you're elected, period. And if you're appointed, you can't do it unless you get an exemption. The law doesn't ask whether you're a special, it just doesn't care, okay? So section 19 isn't what's at issue. The two sections that are affected by your status as a special municipal employee are section 17 and section 19. Section 17 prohibits you from appearing on behalf of anyone else or acting as an agent on behalf of anyone other than you in a matter in which the town has a direct and substantial interest, period. That's what section 17 does. So if you're a municipal employee and you're not a special, so whether you're like a full-time employee like Dory or you're a part-time employee, if you haven't been designated or your position hasn't been designated as a special municipal employee position, then you're a general municipal employee, a regular municipal employee, and you may not appear on behalf of anyone else in connection with a matter in which the town has a direct and substantial interest. That's just across the board. And that's sometimes surprising to people because that's a big deal. So whether you're elected or appointed, part-time, full-time, compensated or uncompensated, unless you're designated as a special, that restriction applies to you, okay? So that's one area. And the other area is section 20, which says if you want to have another contract with the town, so another contract with the town would be like a paid contract for, let's say, between a business that you own or you in a second position, okay, which you get paid for. So if you're going to have a contract with the town in addition to the position that you already hold, elected, appointed, regardless of whether you're compensated, you need to have an exemption under section 20, okay? In both of these instances, being a special makes it much, much easier. Okay, the section 20 exemption for regular municipal employees means you can never have a second contract with your own department. Okay, so you couldn't, especially, it affects selectmen a lot if you were specials because you sign a lot of contracts, so you could never have another contract if you were going to be the signing agent, which in this town you're not. But, so, let's go back to section 17. Section 17 is the agency section, and I just want to tell you what the Ethics Commission has said agency is, so you understand how broad this restriction is. It's any type of activity which would include serving as someone's spokesperson, making phone calls or writing letters, acting as a liaison, affixing your professional seal or signing supporting documentation, or participating as an electrician, plumber, or contractor during municipal building inspections. So all of those things, making a phone call, as we said, sending an email, coming in and asking a question on behalf of someone else, anytime that you act on behalf of someone else. So if you go to a meeting and you are a municipal employee, and because you're on a volunteer board and you also happen to be on your condo association and you want to go to a Board of Health hearing and talk about, something like trash pickup or something, if you get up and you say, and I'm here on behalf of so-and-so condo association, now you've represented someone other than yourself in a matter in which the town has a direct and substantial interest. And unless you're a special, that would be a violation of section 17. So it's really quite broad. If you even get up and you say, look, I'm here on behalf of a number of interested parents, when you're at the school committee meeting, if you're a municipal employee, technically that's a violation of section 17. If you're a special, then you can appear on behalf of someone other than yourself in matters in which the town has a direct and substantial interest before boards other than your own, on matters that you haven't been involved with and that haven't been a part of your official responsibility looking back for a year. So that means that, let's just, we'll use Sean as an example since he's sitting there. Sean couldn't appear before himself, he's not on a board, but let's just say, well, let's use somebody else. Let's use a board, someone on the zoning board. A member of the zoning board couldn't appear if they were specials. They can't appear before the zoning board because that's their own board, and they can't appear before the planning board on a matter that was within the zoning board's jurisdiction within the past year, or in which they actually participated in when they were a member of the zoning board. But they could go before the Conservation Commission or the Board of Health, or they could go before the Council on Aging or the Board of Selectmen, because you're not dealing with things that were within their jurisdiction within the past year, or in which they actually participated. Okay? So being a special makes a big difference in terms of their ability to participate in other activities in town, not activities, but in other capacities in town, interacting with town boards. Okay? Again, if they're not a special, they can't do that. And that does, it surprises people quite frequently, and they say, well, gee, I'm a volunteer. How does that work? It's because of the way it works. Unless you're designated as a special, you're considered a municipal employee, and municipal employees cannot appear as, act as agents before other boards. So the other thing, and I'll answer any questions you have, I'll just tell you about Section 20. So Section 20, again, said you can't have a second contract with the town, which would include a second position, or, like, let's say you have a landscaping business, you couldn't do landscaping work for the town if you were a town employee, unless you fit into one of these very specific exemptions. And the exemption for a regular municipal employee is pretty tough. It requires public bidding or public notice, which is at least notice in a newspaper. And then you have to fit into, there's like a multi-part test that you have to meet. If you're a special, though, you don't have to go through all that. If it's for any entity or in any capacity outside of your own boards, all you do is file a disclosure with the town clerk that says what your financial interest is in the second position. So let's say you're a municipal worker, a municipal volunteer, and then you get a paid position with the town doing minute taking. You would just file for a board other than your own. You just file a disclosure with the town clerk saying, I'm doing minute taking for the planning board for, an hour a week at a rate of $9 an hour. Okay, and that would be it. That would be all you'd need. You could even do that for your own board if you got permission from your appointing authority. And so that's the other part, from the Board of Selectmen. So if the Board of Selectmen said, yeah, you can have this second position with your own department, then you can do that. Okay? So that's why being a special is very convenient. It's convenient because it allows you to do other things in town. And, I made this speech at the Finance Committee the other week, so for those of you who are hearing me twice, I'm sorry. There's two different philosophies about special municipal employees. One town I know has none. They refuse, the Board of Selectmen refuses to make any people special municipal employees, and it's because they get concerned that there's divided loyalties. Either you're loyal to the town or you're loyal to your private interests, but it's hard to do both. So you should only appear before the town in your official capacity if you're a municipal volunteer or employee in this line of thinking, and you shouldn't appear before the town as a representative of a private entity, because how do you, which hat do you have on and how do you figure that out? So that's one frame of thought or one line of thinking. And the other side of that the other side of the coin is, and it's also a good point, look, the people that are most likely to want to volunteer and that most likely want to be involved in a municipal government are also the people that understand how government works and want to participate in municipal government. And why are you shutting those people out who might want to make a living in town, but who want to also participate in government and who are, have the expertise and the experience and familiarity with the town? So it's really a balance of those two issues for Section 17. Section 20 is a little bit different in terms of what the logic behind the restriction against having two positions with the town. And essentially, that section is saying, look, we don't want to give people an inside track. That's why if you're a regular municipal employee, you can only have a second contract with the town, one, if you fit into all the restrictions, but two, if there's public notice or public bidding, if that's required. Because the idea is that people shouldn't just be able to kind of slide into that new job just because they happen to be in the know or they happen to know someone. They already work for the town, so they get this second job, or they're a volunteer and they get this second position. But again, even if they're special municipal employees, it can only be with departments other than their own by the filing with the town clerk. And in order to do work for their own department, they still have to get permission from the Board of Selectmen. So there is still a level of control, but that's where the logic comes from it. It's the inside track avoidance. That's the Section 20 issue. So those are really the kind of the long and the short of the special municipal employee status. One of the other things that came up at the Finance Committee meeting that I should mention is the question of whether the selectmen have an obligation to revisit this from now and again, or in a particular schedule. Whether the selectmen are required to notify people they appoint about the impacts of these various issues. And really, you know, the answer is no, there's no obligation to the Board of Selectmen to do that. Especially now that the conflict of interest law you're required to do a conflict of interest law training. There's information out there that's available and that people do need to know about. But there are people that are exempted from the training, and it might happen that those are volunteers. So is there anything that prohibits the Board of Selectmen from notifying appointees of the implications of the conflict of interest law? No, there's not. And the Ethics Commission puts out a bunch of booklets and materials, educational information that's available, and the board could decide as a policy matter that it will provide for that information to be given along with the open meeting law certification, if that's something that the board thinks is important, because clearly this does have implications. What else? I think one of the questions was, should you have a policy or could you have a policy? And the answer is yes, you can. There's no requirement that you do. I actually don't know of a town that has a formal policy on this issue, but that doesn't mean that it's not a good idea if that's the way that you want to deal with it. The other thing is that you should be aware that there is no requirement just because you make one sort of volunteer board specials that you have to make all other volunteer boards specials. That idea be the same class. It's position by position, not, all volunteers versus not. And there may be legitimate reasons that you don't want to make certain boards special municipal employees, that you want a particular board to have only one master, if we're going to use that terminology. And that's something that you can think about on a case-by-case basis. In terms of reviewing the current special municipal employee status, if you're going to be looking at things holistically, I think it does make sense to take a look at all the boards that you have already designated, so you know where you're starting from, and so that if there's any that you missed that you want to include, that you do. And then the last thing I would say is that both, as I mentioned, elected and appointed can be designated as specials if they meet the requirements. So it doesn't matter how these people come to be municipal employees, whether they're elected or appointed, part-time or full-time. Whether they're eligible depends on whether they meet the hours requirements and the payment requirements, and not on the manner in which they kind of came into their office. So that's the outline.
All right. I don't know if anybody has any questions or comments?
Just, Lauren, how long has the ethics, how long has this existed, this particular special municipal employee?
Well, I've known about it since the mid-1990s, but I think it's been around since the mid-1960s.
Really?
I think so. I know the ethics law has. I'm not certain whether the special municipal employee part has, but it's been quite a while.
Okay, and what you're saying is if we have a list here, I think the last time this was updated, it was given to me, was 2005. And a lot of these committees, they're not even in existence anymore, but you're saying even though you appointed, you gave them special municipal status, and the group changed, the members changed, just the fact that you gave them covers them.
Yeah, that's exactly the case. The position has been designated, so let's just, beautification committee. Let's say there's a beautification committee in 2005, and the board voted to make the beautification committee special municipal employees. Then that committee, the positions on that committee today would still be special municipal employees. And even if no one had served on that committee for 10 years, but you now went and made appointments to it, now those people would also be special municipal employees, unless you took a vote to say that they're no longer special municipal employees. It stays with the board going forward.
What would prohibit you, obviously, if you really wanted to be you could say, we're not going to have it for anybody.
Correct.
And that would really hurt volunteerism in the town of Abington, as I put it. But what would prohibit you from just carte blanche saying every committee we're going to appoint? Because obviously we have committees like this one here that really wasn't aware of the Sage Committee or, Griffin's Dairy. You could go on my term on the thing that we didn't do it unknowingly. And so you had people there that obviously could have violated the law. I don't know, again, why wouldn't the board just all of a sudden say, okay, every committee we're going to, because we're gonna more or less
Right.
allow.
All volunteer committees shall be special municipal employees. Well, the Ethics Commission says, and this is, I don't make this stuff up.
No, I know you don't, I know you
They
don't.
say, let's see, votes should be taken individually for each board or position being designated, expressly naming the positions being designated. So they would like to see a specific vote. What you could do as your policy, like if you're thinking about a policy though, is to say, look, at the time we create a committee, we will address whether that committee will also be will be designated as special municipal employees. So that you get into the habit of saying, yeah, let's have a volunteer committee for this, and let's designate them as special municipal employees, and notify the clerk. So that there's, an expectation that it's going to be dealt with. You would vote it separately, so maybe, as I said, maybe there'd be a reason that you didn't want one committee to be designated like that, but at least it would happen at the same time as you were creating the committee, and people would know. And then in addition, part of the policy would be that the notification would go to the clerk, so there'd be a record that would be easily accessible.
And could you remove that status, the board of select?
You absolutely can. I know anecdotal evidence isn't that great, but I know of a town where there was a lot of special municipal employees. People did not like the result of that because of various things that happened, and they, basically in the middle of something, just revoked the status of planning board members as special municipal employees, which then meant that certain planning board members who were actually attorneys representing clients in cases against the town could no longer represent those clients, and they just did it because they were fed up with the situation. So that happens. It's not illegal. It's legal. The question is whether it's a good policy decision for the board. And that's really, we can talk about the law doesn't require this and the law doesn't require that. There's no requirements here. This all comes down to policy. What the board thinks is the best situation for the town. And the decision is left solely within the discretion of the Board of Selectmen. It is not something that the board is, you're always answerable to the public through the election, but there's no, just because someone asks you doesn't mean you have to, or just because someone says, gee, we don't want to be, doesn't mean you can't leave them as specials. It's really up to you. And, this is one of those examples. It's a majority vote to make this happen. So it's whatever the majority thinks is the right balance for Abington.
Now, say for instance, you get the special exemption, and you want to, we'll go back to the rubbish individual that is a member of a condo association and wants to go to the Board of Health to file. Would they have to file with the town clerk just to do that? Is that?
There's nothing in the ethics law that requires it
Okay, that's fine. That was my
to
question.
just appear on behalf
Now,
of someone else.
Another
No.
question, because there seems to be a lot of big numbers floating out there as far as, say somebody did something like that.
Are we talking about-
What would the likelihood
okay.
be? What would be, you inadvertently, we, the Board of Selectmen, didn't make the proper appointment, and you inadvertently went in front of a board, and there was no financial gain per se, but
Right.
basically it was a cover. What would the likelihood of the?
Let me just speak for, if you don't mind, and Mr.
Sure.
Chairman, I haven't been going through you, so I've just been.
Don't worry about it.
Okay. The way that the ethics law works is a person's violation belongs to themselves. So that's the first thing. A lot of times we get a question, so-and-so is on my board and they keep violating the law and, what should we do? Well, there's really nothing that you as a board, if a member of your own board appears to be participating in something which they have a financial interest or is representing someone that they shouldn't be representing, there's really no way for the town to kind of jump in front of that, except, to file a complaint with the Ethics Commission. And that's really it. If a person chooses to violate the law, the ethics law, whether it's on purpose or by accident, it's their decision, it's their action. It doesn't belong to anybody else, and there's really no way for a town official to prohibit that kind of action. It is what it is. I know that's kind of a overused phrase, but that's how that works. The way the Ethics Commission, when it gets a complaint, it will do an inquiry into it, and it can resolve it in a formal manner, which is, through essentially a public hearing process and evidence and then a finding, or an informal manner. And that is much more of the normal course, an informal resolution. For virtually all of these kind of main three sections of the conflict of interest law, 17, 19, and 20, violations are steep. 17, it's $10,000 or imprisonment for a year or both, imprisonment in a state prison for not more than 5 years, or in jail for not more than 2.5, or both. For 19, it's also the $10,000 and the imprisonment, and 20 is the same. And those fees were raised, they used to be lower, they used to be 5,000. I've never seen a fine that big. For intentional violations, and I'm putting the intentional in quotes, where a person was warned not to participate in something, and they do participate in something in which they have a financial interest, I've seen like $3,000 fines after negotiations with the Ethics Commission. But that's really unusual. Most of the time, let's just say a complaint was made that someone had represented their condo association. They, in the Ethics Commission, would call up the person and say, we've received this complaint about you. They might send them a letter too. They send them a letter too. What are the facts? Well, what did you know? They'll be asked a bunch of questions. They'll respond. And most of the time, the Ethics Commission will send a letter back to that person in confidence, not reporting back to the individual who originally made the complaint. And the in confidence letter will say something like, we've received this complaint. You appeared on behalf of so-and-so. You've informed us that you appeared on behalf of so-and-so. Section 17 prohibits this, blah, blah, blah. Not that it's not important, but, the blah, blah, blah. And then at the end, it'll say, so don't do this bad thing again. And that's really the extent of most of those letters. Again, the things that kind of turn into fines are intentional violations where a person's been warned, either by town council or by the Ethics Commission, or, there's been a whole public discussion about how this person owns property and how are they participating, and everyone at the table said to them, you can't participate in that, you have a financial interest, and the person does it anyway. That's the type of thing where you see fines, but I've never seen a fine of $10,000.
No, because when we talk about volunteerism and stuff like that, there was a lot of big numbers floating around out there that, this could happen and that could happen, and it's refreshing to hear you say that, because it was never included the word warning. It never came out, and I wouldn't want a group, not to say, oh, if I violated the law, I'm gonna be fined $1,000 or $10,000, because you explained it, it's in the spirit of fairness, it has to be really a major problem, not something that's inadvertent. So.
I think we might be crossing purposes here, though. Are you talking about the bylaw or state law?
No, I'm
just
talking
state
about
law.
State law. The
Okay,
bylaws
yeah.
are totally different. I
Yeah,
agree with that.
exactly, okay.
But
Yeah, under state
Can
law.
I just interrupt you for 1 second?
Yeah.
They are two different things, but I think the ethics bylaw of itself is a very restrictive bylaw to volunteerism for any city or town, in my book. More or less, that you have to get this special status, you have the government looking over your head, you have this threat of a fine or a thing. It is somewhat restrictive. In my own experience, it has been.
Well, if we come back just to the state law for a minute, with Section 17, and that was the one about representation, there's nothing that once you're a special, you can just represent, act as an agent or attorney, go to court on behalf of someone, appear before a board on behalf of someone, make a telephone call, write a letter, sign an architect's document, put your stamp on it. All of those things, that's fine. That's allowed, as long as it's not in front of your own board, or a matter in which you were personally involved, or a matter in which was the subject of your personal responsibility, so of your board's, your official responsibility. So Section 17. There could be inadvertent violations by regular municipal employees. There could be an inadvertent violation by a special who maybe they thought it wasn't within their board's jurisdiction, but in fact it was, that type of thing. But I think you're more likely to see a Section 17 violation by a regular municipal employee who doesn't understand that the law prohibits them from appearing on behalf of anyone other than themselves. I think that's where you're more likely to see the Section 17 violations. And so in terms of what the selectman's role is with that, to the extent that the selectman is designating a lot of volunteer boards as specials, if that's what you do, if that's what you decide to do, and where things are right now, that minimizes the potential for inadvertent violations of that section. Because then it isn't a violation to appear on behalf of someone else in some other board. And that minimizes the potential for people to violate it, which means, I think, if we look at the reverse of this, that volunteers have less risk under the law.
Thank you.
Tom?
Lauren, I had a couple of questions. One is how far-reaching this is, and maybe I'll use the example in the schools that it could have changed, but I don't think so. Under ed reform, they've established school councils at each of the schools, which I'm not sure if it's appointed or voted on. I think it might be a combination.
Yeah.
So I'm going to assume, based on what you said, that would be a board commission that they'd have to seek special municipal employee status if one of those members wanted to represent or wanted to interact with the government
In another capacity.
in another capacity. But how about something like the PTOs, parent-teacher organizations, which I don't think are voted on. I think any parent or citizen can go and participate, help raise money or whatever. Would they also have to seek special municipal employee, or are they?
That's a good question. My feeling is that a PTO is a private entity and it's not a public entity. They don't post their meetings under the open meeting law, and they don't have public records requirements imposed on them. For the most part, I mean, there could be a special organization that was kind of created by the school committee, let's say, that involved a lot of parents, and that might be a committee of the town for which you would need to look at this special municipal employee status. But I don't believe that a PTO would normally fall subject to that.
Okay.
It's not a public entity.
How about the school councils?
The school councils are a much closer question. I would guess that they do post their meetings and that they are required to, that they are required to comply with the open meeting law and public records laws. And if that's the case, then they would also be municipal employees for purposes of the conflict of
So
interest
even
law.
though that was a school function, would it be required the Board of Selectmen to grant them that?
Yes, only the Board of Selectmen designates special municipal employees.
Okay, thank you.
In the second question, Mr. Chairman, I don't know if we're going to broaden this, but I did have a question of how our ethics bylaw that is under consideration might apply to this, because I thought I heard you say, Lauren, that there was some requirement, I thought you said section 20, where you actually had a file with the town clerk, and how would that be different? If you're under section 17, you do not have to?
Right.
Maybe
Right.
you could make some comments in that, because I'm a little...
Certainly. Section 17, under the state law, there is no filing requirement. Once you're designated as a special, you're a special, you go about your business. Under Section 20, which is holding more than one contract with the town or more than one position with the town, there is a filing requirement. As a special municipal employee, you're required to file if you get a second contract with the town. So if you get a paid position with the town and you're already a municipal volunteer, you would file, and it's with some other board or committee or department, you would file a notice with the town clerk saying what your financial interest is in that contract, okay? If it's with your own department, you'd not only file that, but you'd have to come to the Board of Selectmen and they would have to approve it, all right? That's the filing requirement for a special municipal employee under Section 20. The bylaw talks about a different kind of filing requirement, and just if you were going to appear in person on behalf of someone other than yourself, with respect to a particular property or some other thing in person, you would make a filing saying you're going to represent that person or entity.
So in the example of the individual maybe representing a condo that participates on a board, would that individual have to go and file with the town clerk?
Under the bylaw, yes.
Okay. And is there any sort of other, maybe negative implication, like if you didn't, it could be considered some sort of a criminal matter that you could be hauled into, court, required to appear because you've in effect broken, a bylaw of the town?
Mr. Chairman, okay, it's getting a little complicated, but I'm going to do my best. First thing I want to make clear is the bylaw and the state ethics law are two totally different things. So this $10,000 fine that we're talking about is under state law. The Board of Selectmen, me, everyone else in town, we have nothing to say about, or we're not allowed to weigh in on whether we think it's a good idea or a bad idea. State law says it's done, okay? So that's that, under state law. Under any bylaw in the town can be enforced through, it's a complaint in court, in district court, okay? Any bylaw can be enforced like that. Can be imposed a fine of up to $300 by the court. In theory, that's a criminal, that's enforced criminally, okay? There's also another option, which you guys just passed, the bylaw for non-criminal disposition, which also allows a fine up to $300, in increments of warning, first, second, third fines. And that is enforced non-criminally, and it can also be enforced in court, meaning you go to the district court to enforce it. So any violation of the bylaws, and I mean any of your bylaws, can be enforced in those ways already.
Thank you.
If you know, and I don't know if you know, but you guys represent a fair amount of communities. I just looked at the list of special municipal employees, committees. There's 38 of them that were appointed back in 2005. Is that common, uncommon? Do you know? I don't know.
So I don't know about the numbers. I do know that generally, in most of the towns where I get questions and see, because I'm kind of seeing it when there's a problem or when people aren't sure what they're doing with something. In the most of the towns where I get questions, it's because someone's come forward, let's say from the Zoning Board of Appeals, and they want to represent someone other than themselves in a matter which the town has a direct and substantial interest. And so they come forward and they say, please appoint the Zoning Board of Appeals as specials so that I can go and work on Project Y. So it's usually, in my experience, kind of driven by this idea of being able to do some other work in town and someone needing that permission. I would have to imagine if you did a survey that there's going to be a lot of towns that have a large number of committees that are designated as specials, but you're probably going to find equally large number of towns that it's much more spotty, based on people, on particular individuals coming forward. And then when those people leave, they don't really, the rest of the board doesn't really care. Now, it may be that you have a lot of people that are more active locally in terms of wanting to work in town, and that could be part of the reason driving the original decision to designate all of those committees as specials. Because if you do have a lot of people that are doing that, or representing condo associations or other groups, then there's a lot of sense in doing that to keep people encouraged about volunteering and not making them choose between making a living in town or volunteering in town.
I'm going to open it up to folks because I know that there's a lot of questions. So, Jan, if you want to come up and ask your question, just so, yeah. I think everybody up here is done, right?
You were here last time.
I know,
It's a
I
regular.
like it here. My question being, as a volunteer, municipal employee, not special, representing a condo association in front of the Board of Health. The Board of Health takes a decision based on that condo association, they vote on it, it's approved. Does that become null and void?
Mr. Chairman, it doesn't automatically become null and void if a board votes on something where there's a conflict of interest that's involved. The State Ethics Commission or a court could undo the action of the board if it's based on a conflict, and they can award damages to an individual if they've been harmed by that conflict. But in the situation that you're describing, the board itself wouldn't have had a conflict. It would have been a person appearing before the board, so I think that would be relatively unlikely to have happen.
So it wouldn't be null and void then?
It would, no decision of a board would ever automatically be null and void because of a conflict. Look at that, you like that there was an answer.
Yeah, no kidding.
That was awesome.
Acceptable. Joe?
Could I see that list of the 38
And then there's 3 add-ons. But these weren't committees, these were.
Okay. Joseph Shays, 3 Wyman Road, Abington. One question, Lauren. If, and I'll go through them, you can answer, if you want, you can answer each one, and answer when I get done. If a member of the Board of Selectmen is appointed to another position, such as representing the town with another group, such as Plymouth County, is that therefore would that selectman, as a representative of Plymouth County, need special municipal employment, or because affect they're holding 2 positions under the town?
Why don't we have Lauren answer? If you have a series of questions, let her answer one at a time so we don't
Right,
get
otherwise
confused.
I don't know if I can keep up. If you're serving in one position and you're appointed to serve ex officio in another position based on the position that you serve in originally. So the selectmen being appointed to the Plymouth County Charter Review or something. I know that that's really a separate committee altogether where you're elected, but let's just pretend you're appointed by virtue of your first position. That does not trigger holding a second position with the town. So,
But suppose that this position is not ex officio. We set up a new committee to study a site for a new fire station, for example, and a selectman is appointed to that committee, and there's no requirement ex officio that it has to be a selectman. Or it's even a member of the planning board or some other board.
there's a section, there's a exception. If you hold an elected position with the town, that doesn't count as a contract for purposes of Section 20. And this is really technical, and whoever said, please use English, I'm so sorry, I'm trying. So it doesn't count as a contract for Section 20. And so you can hold any other number of unpaid positions with the town without implicating Section 20 at all.
How about section 17? Because you're representing the interest of that other committee.
Okay. All right. Section 17 is representing someone other than the town in a matter in which the town has a direct and substantial interest. So you never implicate 17 by representing the town in more than one capacity. It's by representing someone other than the town.
The reason I just asked for that list, the reason I came here originally is, to try and ask that the Tricentennial Committee, the summer band concerts, and those people who served under the Tricentennial in various other functions. We have a group of subcommittees such as the ones that have held the dance, the ones that have held the trivia night, the ones that have written the book, and I can think of at least 2 people on those committees, 2 or 3 people on those committees, so I don't want to name, who appear before town boards on other issues or a member of town boards. So I'm requesting that they all be members of the Tricentennial Steering Committee, the other committees under Tricentennial who have worked with the Tricentennial, because I think under the law they could be considered town employees, and the summer band concert be considered.
Well, why don't we get the answer on the subcommittees under the Tricentennial Committee? The Tricentennial Committee was appointed by the Board of Selectmen, and then there were a number of subcommittees that the Tricentennial Committee reached out to people to see if they wanted to be involved. The Selectmen never appointed those folks, so is that an issue?
If I just might too, I think if I just might interrupt, I think some of those subcommittees were intentionally not part of it, so they didn't have to keep minutes and things like that.
Right.
So just bear that in mind.
I think this is like a mini law school exam, and I don't think this is very
There's a lot
fair.
of trick questions.
Yeah,
coming
exactly.
out.
I'm not sure how to answer these questions. I want to leave the open meeting law part aside. If the Tricentennial Committee was designated as special municipal employees, then subcommittees of those same people, they'd be special municipal employees on their subcommittees too. Whether a totally different group of people appointed by the Tricentennial Committee would be special municipal employees is a question I don't know the answer to. Because it's the Tricentennial Committee, if they were designated as specials, that would be specials. So I'm not sure what happens if there's all sorts of different people that are on subcommittees, but I can look into that. I really have never been asked that question.
I would suggest that for the purpose of the, people feeling safe, that any member of the subcommittee, were called subcommittees, but not such as the fireworks, the dance, the trivia night, and so forth, be also declared special municipal employees.
But just to that point, Joe, that trivia night committee is over. That's all done, right? There's no more trivia nights. The dance committee,
That trivia,
their function has been completed. They're all done.
Suppose somebody brought up a question that somebody did something when a member.
I guess that's the question. Can you go retroactively appoint these people as special municipal employees?
Mr. Chairman, I don't think so. Certainly, if there were complaints to be filed with respect to committees that no longer existed, and knowing that the way that this town has responded to this issue, holding this meeting, considering it other meetings, I think there would be a good case to be made that there was a good faith mistake that was made, and that the Ethics Commission would understand that and just encourage people to be more cognizant of the law going forward.
If I could, Mr. Chairman, I think an issue to the whole debate right now, I think to Lauren's point, very valid point in terms of what would the Ethics Commission look at, I guess my own mindset is that if when we take up action item number 1, I think if we look at, rather than having the broad brush, that we look to see today what it is, committees, whether we want to revisit them, send out notices to all the individual committees saying, look, we're reconsidering the issue, give us your input as to whether you want to have your committee designated, and then we can review it on a piecemeal basis. And that way, we're sending a message that we're being very vigilant in terms of, and taking the law seriously, so that if something ever happened and the Ethics Commission does their research on it, they can see that from our standpoint, we're trying to administer the law as it stands.
I agree.
Pat. And then that way, there are going to be a lot of what-if issues that I don't think we're going to get resolved. So I think, what we've got to do is look at the list in its totality, send it out, and then deal with the subsequent issue tonight in terms of the Tricentennial Committee, from that standpoint.
One reason I am bringing this issue up is because I have, and other people in this town have been, had anonymous complaints made to the Ethics Commission. I had a complaint made, again, about me, that I was serving on too many committees. A couple which didn't even exist, or had ceased to exist before I joined other committees. I had to go through and write an explanation of it. I had to provide information on it. It is not an easy thing to go through. Nobody wants to go through it, also because people can find out who has been accused, who complaints have been filed to with the Ethics Commission. They do find it out. They do find out, especially who's been found guilty, but also who has been accused. And to me, I think the volunteers, you all said, the volunteers in this town are very important. The people who are doing, in some cases, 2 jobs under Section 20. I think for example, the police chief has traditionally also been the head of civil defense. I would assume that under that needs to be declared, that needs to be addressed. And some as a special interest employee, because appeal would be a violation of Section 20.
No, I think the issue on that, Joe, is that the charter language provides that as part of his duties, he will take on that position. So I think when you look at it, I think you've got to look at it as to what the position is and what those duties assume. And by virtue of the charter itself, it delegates that to that position. So that in and of itself doesn't mean, it doesn't give the option of appointing 2 different people. Whoever holds the position of police chief also holds the position of civil defense or emergency management director.
That may be a bad example, but I just think it's something the selectmen need to keep in mind, that, people are accused. It's inadvertent. Is a problem from them. They may not get a fine, they may get a warning, but it's still a problem for them. So I think you people I think the Board of Selectmen need to keep in mind that, this town depends tremendously on its volunteers.
Well, honestly, Joe, that's why we're here tonight, is because this hasn't been looked at in
Right.
7 years, and it's
Right,
something
I
that I
agree.
thought need to be looked at, because to me, letting something like this sit out there for 7 years without some
Right.
sort of review and some sort of a regular review is not a good thing. So that's why we're doing this tonight.
Okay? I mean, yeah, because I'll be honest with you, one of the positions that is not on there is the position of advisory board for South Weymouth, for the Southfield. That position's not on there. I would assume, because I have that position, I could be considered in violation.
Well, you're only in violation
Again,
if you're
you're an
representing
original,
somebody
yeah,
in front of
you're
a
talking
town
about
board.
original entity.
But you're holding, but appointed by the selectmen.
I'm sorry.
I just am aware that what people have done as far as violent complaints.
I know,
And-
it happens, but there's not a lot you can do
But
about
I-
people filing complaints. They have
No,
to
but I
go
think
through
you can,
that.
you people need to keep in mind that it is important to give protection where it's deserved for the volunteers. Thank you.
Thanks, Joe. Did you have something to say?
Mr. Chairman, I just want to point out, anybody can hold any number of unpaid positions with the town without violating Section 20. So if you're a volunteer and you want to volunteer for 10 boards or 20 boards, and you're appointed by the board or whoever else, that's fine. As long as you don't get paid, you can hold any number of unpaid positions with the town without implicating Section 20 at all.
Anybody else have any? Mr. Janowitz? Yeah, so,
And stand up.
get your face on TV.
Francis Jenowitz, 1277 Washington Street. In regards to this 268, I was wondering, there's a lot of talk on 17 and 20. And if you were to grant this, would you have to spell out just 17? Or there might be in a group of 12, someone in one category, someone in another. And would they be included? You know what I'm saying?
So, Mr. Chairman, if you're designated as a special municipal employee under 17, that means you can appear on behalf of someone other than yourself in a matter in which the town has a direct and substantial interest before boards other than your own. It doesn't necessarily solve any Section 20 problem if a person has a Section 20 problem, which means they hold at least one paid position with the town, but more than one position with the town. And they would need to separately explore whether they can fix their Section 20 problem. I will tell you that in my experience, I said earlier, I get calls when there's a problem, and I get a lot of calls about Section 20 issues, people that just didn't realize that that might be an issue. And, then you kind of go through the process to see, okay, do they fit into the exemption under 20B? And if they don't, are they specials? Are they specials? Can you fit them under 20C or D? And if not, can they fit within 20B? So that's really an individual exercise. And one of the things that I said earlier is that everybody's conflict belongs to them. So if a person finds himself in that situation, they should approach their department head or their board chair and ask for either the ability, and I know now I sound really self-serving, to talk to council about it, or they can call the Ethics Commission directly. When they do that, though, they need to be very careful, and the Ethics Commission does two things. One, they give out legal advice going forward, and two, they enforce violations looking back. If you call up and you say, I serve in these two positions and I've been in them for 2 years and blah, blah, you've really just kind of reported a potential violation to the Ethics Commission. So you need to be careful about how you phrase things. Something like, if I were to be appointed to this second position, is that a problem? But again, the Ethics Commission can only, they will give you an opinion, usually just verbal, but they're not gonna, if you don't tell them all the information and then you get a complaint, they're gonna look at what you said and they're gonna say, well, you only told us half the story. If we'd known X, Y, or Z, we would have told you to do Y. So you need to use them carefully in terms of how you approach them.
Thank you.
Does that answer your question, Frank?
Yes, thank you.
Anything else? Anybody else have any other questions? Yes, sir.
Good evening. My name's Bill Mullen, 25 Block Street. I also suppose I have the pleasure of serving on the zoning board. I've done so for 3 years. I think in this matter, having as much protection for people who volunteer for the town is an important thing. It strikes me that people who volunteer for many things. My wife does Boy Scouts and Girl Scouts. She's trying to get me involved in Boy Scouts. In the last municipal ballot that we just did, I was looking and I was disappointed to see blanks on the ballot, especially one for, I think it was the Veterans Memorials. And I'm sitting there saying to myself, my God, these are guys who we're trying to honor, and no one stood up to the plate. And no one said, I'll throw my hat in the ring and serve on that committee to honor those people. And, when I look at it and sit there and go, well, if I'm sitting there and I'm exposed, and not necessarily to a $10,000 fine, because, that's not realistic. That's probably as realistic as getting busted for throwing your McDonald's bag out in the woods. It's not going to happen. But there's a chilling effect as well, whereas, we have a tendency on zoning to annoy somebody on a monthly basis. Because no matter what we do, there's somebody who's not going to be happy. We've studied it. We're trying to make the best decision. And yet at the same time, there's someone who's sitting there saying, oh my God, that can't be a fill in the blank, a parking lot. That can't be an apartment building. And we do the best that we can. I think the chilling effect is if someone starts to file ethics violation after ethics violations, and it becomes, codified, and it becomes recorded in public records, and, okay, I didn't have a fine, or anything like that, but next thing you know, I'm looking for employment. And in this day of the internet search and that sort of thing, oh, there's Bill Mullen, he's, investigated for an ethics violation. Well, geez, Mr. Mullen, we were gonna give you that position, but now we're not so sure about your, I'm sitting there going, my goodness, I volunteer, I don't, how many times you ask someone to volunteer and all you get is everyone looking at their shoe tops? I look at Mr. Riley over here, who, I have the pleasure of running into nearly every month, and, I believe he coaches, he's on a board here, and yet he's oftentimes on the other side of the desk before us. We don't always give him what he wants, but he's always professional, he's always prepared, and he's not looking to do a helicopter pad in my backyard or anything like that. And I think to try and stifle the people who are willing to give their time and not put some layer of protection, not put some wall, you're just exposing yourself, especially on some of these boards, as a way of recrimination for every little person who doesn't get their way. I thank you very much.
Thank you.
Yes, Lauren?
I want to clarify one thing, Mr. Chairman, and that is that most of the work that the Ethics Commission does to follow up on complaints is not public. They keep the fact of the complaint confidential, the fact of the inquiry confidential, and the result confidential. And the only way that it becomes part of the public record is if the individual discloses that to, so if somebody says, oh, you can't do that, you have a conflict, and the individual says, no, I don't. Right here, the Ethics Commission said that I am fine, I can do what I want. At that point, the Ethics Commission will probably respond by saying, yeah, we did issue an opinion in that. But otherwise, they won't confirm or deny whether a complaint has been made. And it's only when it's resolved publicly in one of the public ways, either that they go through the whole public hearing process, or that the individual agrees to pay a certain amount and avoid the public hearing process. And so then that, I forget what they call it, like a public something resolution, they make it public that way. But those are very far and few between.
Great, thank you.
The other thing is that the bylaw review committee, Kathy had actually found a special municipal employee administration process in the town of Amherst.
Yep.
So I'll just give that to
Helpful.
you for your records.
Great, thanks. Okay. Yes, Mrs. Wheatley.
Phyllis Wheatley, 286 Randolph Street. First off, I think you said that in a town over 10,000, the selectmen are absolved from this policy or this bylaw. They do not fall under this bylaw.
We can't be
No, we can't
designated
be
special
municipal.
municipal employees, so we don't have the right to go in front of other board. I couldn't go in front of the planning board or the zoning board.
You would have to absolve yourself.
I can't
All right.
do that, yes. Or any of us wouldn't be able to.
Do any other towns in the Commonwealth have this? This bylaw?
We're not
We're
talking
talking
about
about bylaw.
We're talking
Not
about
there
the
yet.
special municipal employee status. We're not talking about the bylaw.
So I can't speak now about several things like that, or outside of that.
No, because we're not talking about, the bylaw is a separate issue. That's going to be,
Are we going to
Debated.
talk about that tonight? Because there are so many people that are so upset by this bylaw, and so many people who are not going to volunteer ever again
well, number one.
because of this bylaw.
Well, the bylaw hasn't been adopted yet.
If it is passed, you're going to find the volunteerism in this town is going to practically disappear.
I am hearing you, but that's not what we're talking, tonight was
All
just
right,
basically
what did you
special
hear me?
municipal, I did, yes. Okay. Why don't we take this out of order so we can take care of the Tricentennial Committee volunteers. There is a request from the Tricentennial Committee volunteers for special municipal employee status.
Mr. Chairman, I'll move that we grant special municipal employee status to the Tricentennial Committee volunteers.
Yeah, I'll second that, but there was also a concern of the summer concerts.
Well, let's do them one at a time.
Okay,
So
that's fine.
we're in compliance here. Is there any discussion on on the motion? If not, all those in favor?
Aye.
Aye. All those opposed? Okay, Mike, if you want to, we'll take up the Summer Concerts Committee
I'll make a
also.
recommendation, we approve the Summer Concerts Committee as special municipal employees
Second.
status.
Second.
And a second, any discussion? If not, all those in favor?
Aye.
Aye, opposed, that's unanimous.
And I know there's other committees, yes. Jane?
Just want to make sure this does cover the volunteers for everything we're doing on the tricentennial.
It covers what we can cover, I guess is my answer.
You know, at some point, I think you really have to look at it. We get a little bit too technical with what
Yeah.
exactly we're going. We really have to look at what is the law trying to accomplish? And are we too technical in saying all these things? I really think we have.
Then
that
I don't think,
going over, but-
I don't think they're trying to accomplish that. If you're working on the trivia night as a volunteer, that you need special municipal employee status. I think it's, if you're an appointed, correct me if I'm wrong, if you're appointed or elected committee, then you need that special municipal employee status. If, again, if you want to represent somebody in front of another board or committee, that's all that, so for most people here, it doesn't apply because they're not representing somebody. For you, I know it did, Jan. and-
Yeah, forget it. Some of those people may be on other, I wouldn't know, we just have volunteers coming forward. So, like I said before, we're gonna go away.
Right.
You know, the tricentennial will not be.
After September, they'll be
I'm not
gone.
gonna be here 300 years from now or anything else. But I just wanna make sure that the volunteers that do come forward, you
Lauren?
know, are okay. We just wanna get through September.
Mr. Chairman, the question would be whether those people are municipal employees, and I think it is unlikely that they would be. They're just helping out with a particular program that's being run. I don't think they're town employees for purposes of the conflict of interest law. However, because the issue has been raised,
You
I
will
will look
check it
into
out.
it and I will get back to
You will
you.
let us know. Thank you. Joe, did you have a question?
Yeah, I am very cautious, both because of what I've seen happen and because of what happened with me personally on CPO. I know of a couple of people who somebody wanted to stretch the law, make accusations, who could be at risk because they are doing things on committees, groups helping the tricentennial, which is still active. And I don't want, I'm not gonna name the names of them, but they're good people trying to do something that they're not.
Well, Lauren's going to check that out, so, right?
Right, just, that's why this whole subject gets, and as Mr. Mullin said, to chilling effect. If somebody comes back and says, somebody filed a complaint against you, and you get these things, you have to say, the complaint was filed on a plea. Sometimes people don't hear after the first time of that complaint was filed. And somebody can file a complaint anonymously, out of thinning. That's happening.
Okay.
Okay.
The other item is the discussion on drafting and adopting a policy regarding special municipal employee status, which I
Mr.
think is
Chairman, I'm gonna make
an
a
advisable thing to do.
I'm going to make a motion that we send out a letter to all committees that are on the list that has been provided to us, that give them 1 month to respond to, for lack of a better word, to show cause as to why they should not be removed from the list. And those that don't respond, then we will be taking up an action subsequent to a month. It gives them ample time to meet and ample time to respond, and the selectmen will at that point review the list and make a determination as to the continuation of those particular committees.
I'll second.
A second. Any discussion on the?
I just would
motion?
have the question, when I reviewed that list, are there some committees that are no longer in existence that we should take off tonight?
Those might be the ones that don't respond.
Yeah. If they don't respond, then they're going to
No,
be
you're
off the
right.
list
There's a
anyway.
But who do you send it to if there's no committee, I guess is the.
That's work for, I guess, the office.
Figure that out.
Yes. Then you can, Sean, if you want to.
And the other thing, just in terms of it, there's the committees and then there's individual positions, and I don't know if you wanted to be looking at that at the same time. It's, obviously, that's up to you, but if there's our single positions.
Whatever's on that list is my motion.
Mr. Chairman. Sean Riley, 26 Russell Lane. Just speaking on the motion, my only concern with that is you're saying, unless you tell us we're gonna remove your special municipal employee status. My fear.
No, that isn't
Oh,
what I
okay,
said.
what's the motion? Maybe I misheard
No,
you.
no, no. My motion was, in essence, to show cause why we shouldn't.
Why we
remove it.
shouldn't be removed from the list.
Doesn't
At
say that we are going to.
that point
It
in time, we
says-
will review the list.
Okay, my
make a
concern,
determination.
my concern only would be, unless you're sitting here in this room tonight or watching on TV, a lot of those other groups, commissions, whether it's the ADA commission or the, whatever it is, might not understand the ramifications of not responding to you. It may be that you say, if you'd like to be removed from special municipal employee status, let us know. My fear is, people get this letter and say, if you'd like to, contact us if you'd like us to take you off, or if you'd like reconsider, or whatever, and they're gonna say, what the heck is this? I don't know, we'll have to get some answer and come back next month to discuss this, or whatever, and they don't respond, they get taken off, and then we're in the situation where these innocent volunteers have lost their municipal employee status. That's just my concern. I don't know the perfect way to do this, but I would be more hesitant to remove people.
Well, again, John, we're not removing anybody. All it is sending out a letter asking people to respond as to whether or not they think they should continue with that status.
But I don't think they understand the benefit of continuing or getting off.
I'm going to disagree with you only because if there's people who are representing people in front of boards, and again, this is all this is about. If there's people who are representing people in front of boards and committees, I think if somebody sends me a letter and says, we're going to remove your special municipal employee status for you to be able to do that, then you're going to do something about it.
I disagree, because I think most people think that they're talking about me and you as attorneys, when it really goes into people who are, for example, a friend of mine is a volunteer on the Strawberry Valley Committee. He's also on the Greenway Boosters Committee. If he steps in front of the selectmen or the school committee as the chairman or as the president of the Greenway Boosters, and he's not a special municipal employee, he has now violated the conflict of interest law. I don't think he knows that. I've got friends of mine who may be on the Griffin's Dairy Committee, and if they're also in the St. Vincent de Paul Society, and they appear before the selectmen for permission to do a fundraiser, they've now violated the conflict of interest law if the Griffin's Dairy wasn't special municipal employee status. This goes a lot farther than people understand. I mean, Port Town Council just had a barrage of questions from the 12 people here in this room. There's more than 100 people that are volunteering in these committees. And I'm not saying that you guys are gunning to take people off. I just thinking if you ask people, do you want to stay on, they're going to say, I don't know what it means to stay on or stay off. That's my concern.
But I think we have to start someplace.
Right.
And
Yes.
I think the issue becomes, is by starting that someplace, by defining a date certain, and then once we get the list, then we make a determination at that point in time. If there is a number of people that haven't responded, then we have a workshop meeting. Or it isn't, the motion is not designed to say definitively what's going to happen. It's designed to start the process, which I finitely think we need to do. And with that said, then it becomes a judgmental issue, is once we get the final information as to where we go from there. So I think it's a starting point.
I agree. I fully support the selectmen reviewing it. Don't get me wrong. I just want to make sure that the volunteers understand the pros.
No, I think, believe me, I think everybody, at least I do, and I'm quite sure the others do as well, is the volunteerism that people do. We've served, that's how we came up, serving as volunteers. We understand the sensitivity of it, and we've got to make it fit within the law. The crux of this problem has become, is just recently, the legislature has upped, the ante, so to speak, where it become basically a slap on the wrist. They've, because of the problems, not in the communities, but because of what's happened, the indictments in the legislature, that they've responded in such a manner that maybe they've tipped the scales too much, against the local people. But unfortunately, those are cards that are dealt to us that we got to try to deal with the best manner that we can. But we certainly don't want to put anybody in harm's way, especially in light of the steep fines that could be, done in that manner. So I think we've got to start somewhere, and that's why I made the motion, and I think it's been seconded.
I did second. I just wanted, we're not the enemy. We want to do the right thing. We're dealt this deck of cards by, like what Kevin said, because, there's too many convicted felons in the House right now, so, so they impose these laws on us, and we want to do the right thing. I think sometimes you're viewed as some of the converses, like we're the enemy, and we're not. We're not trying to throw anybody under the bus. We want to foster volunteers as much as we can. I just might want to go to Joe's point about the number of violations that were reported before. We did have a couple people on some boards here in town that were sour grapes no matter what they looked at, and I think that created a whole lot of problems with those types of violations. I don't know what we can ever do about that, but believe me, as far as the boards that they're not notified or might not, appear to, I'll do my very best, and I'm certain the members of the board will, to notify them and give them a heads up of this is what we're trying to do. So, if we can rest assured of that.
Yes, Joe?
Your response to Selectman Freeney's comment? At one point, Abington had a very large number of people, I think it was the second in Plymouth County to Rockland, reported. I think at one point, out of the 70 that were complaints that were filed, only one had any finding. I mean, it was basically open, some people were taking it as open season
Absolutely, Joe. I
to
couldn't agree with
take
you
out
more.
personal grudges.
Yeah, it was, truly.
And I think we need to keep that in mind.
Yep.
Because you still see that stuff going around in the blogs that, oh, look how many ethics violations we had. How many
Joe,
complaints?
don't read the blogs. Doesn't help.
I realize it doesn't help, but sometimes it's a way you get some information on what people
Oh,
are doing.
no, please, spare me.
Unfortunately, it's the truth.
All right, last comment from Mrs. Wheatley, then we have to,
Oh, okay.
Good night, Joe.
Well, that's okay.
no.
I was trying to get yourself.
I know.
No, I agree with John, that if you send out a letter like this, and I know you have to start somewhere, and I agree that you do have to start somewhere because there's a lot of problems in this town. But I also think that a lot of people don't understand what's going on in this town. They need explanation of anything and everything in this town. If you're going to send out a letter like that, you have to tell them why.
Well, I think that will be
Not
part of the letter.
just send
It's
the
not-
letter
yeah,
out.
That's gonna be, no, it's not gonna just, I mean, there will be some explanation as to,
Well, I certainly hope so, because there's not a lot of explanation going on in the town.
thank you, Mrs. Wheatley.
Oh, you're quite welcome, Mr. Irvine.
Mr. Chairman,
Yes.
Mr. Riley did raise a question in my mind in the example of the member of the Strawberry Valley Golf Course Committee and the Greenway Boosters. If one of those committees was appointed special municipal employee status and the other wasn't, and a member did appear before a board, would they be in violation?
Well, the Greenway Boosters wouldn't be special municipal employee status because it's not a
Okay, well, let's talk about the fence viewer. Fence viewer
Lauren?
in Strawberry Valley, let's say. Somehow we didn't make the fence viewer.
As a special municipal employee, you'd be subject to one set of rules, but you'd be a municipal employee, so you'd be subject to those rules. So if you're not a special municipal employee in each of your positions, then you're stuck with, for the Section 17 issue, you wouldn't be able to appear.
Gotcha.
Okay. There's a motion and a second, I know. Any other discussion? If not, all those in favor of Mr. Donovan's motion signify by saying aye.
Aye.
Aye. All those opposed, the ayes have it. Okay, you got that, Dory?
Yes,
All right.
thank you.
Okay, next on the agenda, approval of minutes of May 7th, 2012, open session.
Move we approve?
Motion to approve the minutes. Is there a second? Second by Mr. Dion. All those in favor? Aye. Opposed? Ayes have it. Public comment? Any public comment other than what we've already heard?
Just remind everybody that we have a selectmen's meeting. May
Yeah, we have a
21st,
selectmen
5 p.m.
May 21st, 5 o'clock PM. And town meeting is May 21st at 7 o'clock PM at Abington High School.
5 o'clock.
5 o'clock, right. That's for us.
Posted?
Yep, it will be posted
You'll send
tomorrow.
a note around to everybody, a 5 o'clock meeting at the high school for us.
You want-
Just so
Certainly
Kenny
will.
knows too.
Absolutely.
Thank you.
Do we
All
have
right.
anything from the bylaw review committee that they want us to know? No,
We're
no.
not really talking about the bylaw.
No.
tonight, so
That's not this.
Okay, is that it?
Yeah, we have a motion to
Move we-
adjourn.
Move we adjourn.
Is there a second?
Second.
All in favor?
Aye.
Aye.